Welcome back. You're watching Prime Property. Time now for our Property Doctor segment where we get experts to answer viewer queries. This week we're answering legal queries that have been raised by our viewers, and our experts of the day is Weber Gaggar from Gaggar Associates. Thanks, Weber, for joining us here on Prime Property. He's got 14 years of experience in law. One of the biggest cases that he has won was the one against DLF at the Competition Commission of India, where the company was fined 630 crore rupees. Well, let's get down to business, Weber. And our first query of the day is coming in from Abhiraj. Thanks, Abhiraj, for joining us here on Prime Property. What's your query?
So I've taken this property as Sector 137, Lodges, Blossom County. And as per my understanding, there is a Supreme Court ruling which says that, the builder is not allowed to sell the parking space. However, the builder has charged me close to 2 lakh rupees for the parking. So what is the, the status on this, and if you can tell me the legal action that can be taken?
So there is a judgment of the Supreme Court called the Nahalchand Daluchand judgment, which clearly laid down with respect to, however, the Apartment Ownership Act in Maharashtra, that car parking cannot be separately charged for because it forms a part of what is called as common areas and facilities. That judgment would become applicable to you as well. And therefore, you can definitely write to the developer to tell him that he's not allowed to charge for this. In fact, your act itself also provides that common areas and facilities cannot be separately charged for. That being the case, if the builder is not willing to give the money back, then you will have the remedy of going to the Consumer Forum and asking for that money immediately.
So, Abhiraj, as per the Supreme Court, you don't have to pay that 2 lakh rupee payment for the parking lot. Right, time now for our next query. It's from Kapish Takania. He's joining us on the phone line. Kapish, what's your query?
Thanks, Santa, for connecting. My query is regarding one of the builders of NCR region by the name Imperia Structures Private Limited. The builder is doing malpractices by demanding payment on a construction-linked plan before the construction of a particular stage is complete. So what has happened is that there is a demand raised for the completion of third floor. However, the construction has only been completed up to the second floor. So, and I have all the documents and pictures which proves what I'm saying. However, when I take it up with the builder is arrogant and not responding on the mail. The second concern is the builder-buyer agreement writes down that casting of third floor. Now, casting of third floor, the way I read it, means that the casting of the third floor has to be completed, which means that not only the bamboos and all has to be planted, but the cement and other materials have to be poured in, and the casting of the floor has to be completed for the entire tower, and not maybe just beginning of a particular bamboo structure and those kind of things. So these are my major two concerns, where I believe the builder is intentionally following a malpractice. However, I also do not want to cancel my deal with the builder. I simply want him to get right and demand on the right times of construction, also to compensate me for the undue payments that he has taken in the form of interest.
Kapish, step one, I hope you have recorded all of this in writing and have communicated this to the builder, because you will have to build up a case on what you're talking about. It will be an evidentiary issue. Number two, if despite your communications and your protests, he's not reacting, please send him a legal notice encapsulating what you're saying over here, including the photographs, which would be with the date on when you have taken the photograph, to be able to prove that when the demand was raised, the construction was not at that level which he was demanding. If that be the case, then you will have to, within your legal notice or within your communication, communicate very clearly to him that this amounts not just to a consumer civil issue, but again, this is a gross misrepresentation coupled with dishonesty. It could have serious penal consequences as well. Normally, if the builder is able to understand what you're saying, he would be well advised to change his practices, because it doesn't make sense for him to do this and expose himself to such severe liabilities and criminal actions, etc. However, if he still does not come good, then you will have to take up the matter before court, before appropriate forums. Your lawyers will have to go through your agreement and see which are the best remedies. You may have to go in for arbitration, etc. You are not required to necessarily cancel or exit the project. You can stay in there, you can fight it. In fact, if you go to the first principles of contract law, there is something called a reciprocal obligation. You can be required to pay only if the builder is performing his obligations, which is of construction. So I agree with you, casting cannot just be the bamboos or a flimsy structure coming up. Casting means that, the floor has a cement, it has a proper structure in place, etc. And then if you've agreed to that model, then yes, the demand has to be paid. As far as the fact of you recovering interest is concerned, I'm presuming that is only for the first two floors which have been built. I'm not too sure what the, how premature the demand was. But if there is, then again, that's something that you need to build up. But please also be aware of the fact that if you take this too far, or if you take this into litigation, then you've got to do a cost-benefit analysis, and that's something the developer is well aware of. So you may want to think out of the box. You may want to sit him down across the table, find a solution, not take this up as a complete war just yet.
Okay, Kapish, I hope that helps you out. Those are the options that have been laid out for you by Vaibhav. Thanks for joining us here. On to our next query now. That's coming in from Sandeep Agarwal. He's also joining us on the phone line. Sandeep, what's your query?
I had purchased an apartment in the Bestec Builders. It was called Bestec Park View Spa, located in Sector 7 in Gurgaon. The builder handed us over the possession of the said property in October 2013. At that time, he has not informed us any VAT to be payable by us. Now, when I am looking to get the property registered, the builder is demanding a VAT at the rate of 4.2%. Is the builder legitimately asking this demand, or is he just trying to take advantage of some undecision by Haryana government?
What you will need to see, first of all, is in your agreement, what is the clause relating to taxes, what is stated therein. If the clause says that all current and future taxes which are going to be relevant for the project will be borne by the consumer or by the allottee in this case, then you might well have to pay for that. If, however, your clause says that all, up-to-date taxes have already been taken care of and there will be no new further demands, then you've got a very legitimate case for saying that you're not going to make this payment. There is a larger issue at play as well as to whether at all it should be the builder who should be paying VAT, or is the VAT supposed to be paid by the consumer, and that issue is still at large. But you may want to visit your agreement very carefully and see what your clauses say in this regard, because there's bound to be a clause for this particular situation. It won't say VAT, it's going to talk about taxes in general. Can a consumer be foisted with a liability which is not expected at all at the last curve of, trying to take possession? I think a lot of courts are going to be quite sensitive about this issue and in favor of the consumer.
So you need to go back and read your agreement. Thanks, Sandeep, for joining us. On to our next viewer query. It's a lady joining us on the phone line, Pragati Bhargava. Go ahead, Ms. Bhargava.
My grievance is with respect to a group called Landmark Group, which is based out of Gurgaon, Haryana. And they have been actually doing a lot of projects in terms of, independent floors and plus commercial buildings, residential, projects as well in Gurgaon and around. I had invested in one of their commercial projects, basically, which was for shops and, basically portable business units kind of a project in Sector 67 in Gurgaon. And the investment was not a large one, but around 15 lakhs upfront I had paid in 2010 of July. So almost, I would say, 4.5 years back. And this project had already started then. And this particular project had a short scheme of 12% return for 9 years. And it's been more than 1.5 years since the builder has stopped paying the short return. In fact, the TDS which they had been deducting earlier on the short returns payment also doesn't show as if the builder has paid the tax to the government. And when we approach them, the only thing which is being mentioned by the builder's staff is that whatever amount is due to you in terms of a short return not being given to you will get adjusted on the total amount that will get due to you on possession. So, my grievance is, the management is not forthcoming in terms of really telling us as to when this project will, come to a stage when the possession is really expected, because it has already been delayed by, almost 1 or 2 years. We had approached the builder and requested either they start giving the returns again or whatever is being due in terms of pending amount, or, what is the way they can refund the money back if we don't want to stay in the project? So what is the way out? Like, how do I get my money back, or what action can I take against the builder, besides, of course, really going to a consumer court, which is a long drawn process?
So you have 2-3 options. A, I don't think you can go to the consumer court at all. I don't think that forum is open for you, because you would be treated as an investor in a commercial property, which should relegate you to the civil courts. I think you may want to seriously explore what is called a pre-litigation mediation route, which means you can write to the High Court and the mediation cell comes into play. It calls upon the builder, makes the builder sit across the table, and tries to, they're trained mediators, they try and thrash out a settlement if possible, because you're really looking at an exit and the builder knows he's done wrong. If that does not work out, and it is not mandatory that you do this, but it's an option you may want to contemplate. But your route in this is a clear-cut criminal case. Actually, more than even a consumer case, this is a criminal case where they have, this is amounting to a fraud in terms of they've induced you on a certain representation to invest your money. They're going back on their representation. The intentions seem to be dishonest. They cannot turn around and say, oh, we'll adjust it towards the end. It is not for them to say. This is a breach of contract, and it seems to be a malafide or a dishonest breach of contract. The police may take cognizance of it. So I think that is going to be a far stronger and appropriate route for you. If you want to be able to pursue even a civil remedy, then you will have to go to the civil court, or if there is an arbitration clause in your agreement, then that would be your option. But you may want to try reconciliation before you go aggressive, because no matter what legal route you take, it is going to be a bit time consuming.
Also, hasn't the case that we've seen with, for example, Vigneshwara developers offering assured returns, hasn't an important precedent now been created when we talk about these kind of schemes?
Absolutely. Till, I would say, 2-3 years back, the police would, look the other way on matters like this and say, oh, this is just a civil transaction. But now they've realized that this has become the modus operandi for a lot of the developers. They are being able to raise a lot of money from the market in this manner. The money is being diverted into various other, projects or other things, rather than being invested in the project for which it's been raised. And then they're going back on all the commitments. So, I mean, that is as straightforward a fraud as can be. Whether it amounts to a criminal breach of trust or it amounts to cheating, as is commonly understood, that's a matter for investigation. But criminal conspiracy with fraud is certainly now something that the cops have woken up to and are taking cognizance of in these kind of matters.
It really takes care of the health check of these people. I mean, they have been getting into, as you rightly said, into multiple projects, and then tell people around that financial health of the company is not good. So what is the kind of regulatory framework is really there to check on these people as to how many number of projects they can really take in a year, or, for a certain time frame?
Well, unfortunately, I don't think there are. And I think that's a very valid suggestion. I think that's something that the authorities should seriously consider. But I'll tell you that there are regulations in terms of, in Haryana, for instance, Haryana Apartment Ownership Act and the regulations which are there. They do say that the money has to be utilized for that particular project. So there is no limit on the number of projects, but diversion of funds into other projects is something that is frowned upon even under the law there. And you may want to make use of that provision.
Right, so that's what we have on Property Doctor this week. Thanks for joining us. Remember, you can always send us your property queries, feedback, or experiences with developers that you want to share with us. Our email address is primeproperty@network18online.com. You can also tweet me. See you same time next week.